In the aftermath of the two recently adjourned Supreme Court prosecutions, adjourned because judges thought that the legal aid provision of aid was inadequate for the needs of the case, the Director of Legal Aid publicly supported the position they had taken, and by implication rejected the position taken by the judges, and that seemed to be an alternative to saying that we just can't afford to do what we have to do. Is that a right position to take?
The Legal Aid Fund is under incredible pressure. We are an independent statutory organisation. We get funding from the Commonwealth. We get funding from the state. We have to try and eke out that funding, not just to criminal trials, but to a whole range of legal issues throughout the state, whether that's representation before the Mental Health Review Board.
Sure, so you're adjusting what you do to fit the budget you've got.
That's right.
Should legal aid be defending the inadequacy of its budget by saying, in effect, we only have to do what we're able to do? Or should they be publicly standing up and saying, this is inadequate, if we're going to do the job properly, we need more funds?
It's a particularly challenging situation where you're trying to work a system or as an institution that is under-resourced. And I don't think it's a challenge that necessarily is restricted to legal aid or anywhere. Any social system or social service often faces the same dilemma, in fact. Do you continue to try and meet a very full and broad mandate set for you as an institution or as a service, and often very badly underfunded in terms of that? And what are the choices that you need to make within that? I think almost inevitably the choice that you do make as an institution or a service in that is that you do the best that you can under those circumstances.
But then the question is, what's your public stance to be? Is your public stance to be, we're doing what is appropriate, or we can't do what is appropriate because we're underfunded?
I think it would be very difficult for a service or a system to indicate that it's providing an inadequate service. So I have complete sympathy in that particular sense for not being able to convey that in many respects. I think the answer for me would lie in the type of institutional standards or service standards that you need to set in place that provide you with some mechanism to be able to indicate where services are not meeting a particular standard, that you actually have to withhold that particular service. So I think the institution in that particular instance, or the service in that particular instance, has to build in the ability to actually protect itself through those types of mechanisms. So it would be adequate for me to say we don't feel that the service in this particular instance can meet the quality standards that we've set in place that ensure, for instance, an adequate access to justice. And in that particular instance, we feel we cannot meet those standards, and therefore we have to withhold the service that we have.
What are the difficulties facing a government-funded organisation when confronted with a government loudly proclaiming that it is doing great things for access to justice on one hand, and B, being underfunded and unable to do the proper job?
Of course, I'm going to say that what they should do is stand up for the principles of fairness and what they're there to do, which is to provide proper and adequate legal services to those who can't afford it.
No, they shouldn't be doing it, but there's a good reason why they're doing it. So there's an imbalance in the spending in access to justice. There's too much spent relatively on courts and on litigation, and not enough spent on early intervention and prevention, including things like legal aid.
The real question is, I suppose, whether it's still possible to get into human rights and pro bono work without going to the big end of town.
Well, I think there is room for thinking about slightly more innovative ways in which to draw in lawyers into, for instance, either international rights or even NGO work. And that could be through particular types of partnerships with large kind of law firms and so on as well. So not quite, it might be a hybrid of the secondment situation, but more triangulated work, I think, between an individual who's interested in entering a particular scope of work, together with a partnership between, for instance, it could be an NGO like my own, together with a law firm, to think about an area of work that really does provide a grounding in a particular area of rights. So you have the advantage of having a contextual kind of workplace that provides you with the opportunity to really pursue that, but at the same time the backing of the professionalism of a law firm that can provide support for that. Now, with the CLCs and with the secondments that take place, I think those are fairly common. It's not that common actually within NGOs working in rights areas.
Demand for volunteering places at CLCs is so high that it can take over a year to get one, and it takes a long time for volunteers to be a net asset to their firm. Isn't it possible for firms to tap this pool of waiting volunteers in innovative ways, perhaps through short, focused training programs that deliver paralegal type training?
We're acutely aware of the difficulties in getting a volunteer position at a community legal centre. You tend to have greater popularity in those centres where lawyers and law students live. So one tip I always had to people is go to the less popular centres, go further out, don't look at just your Fitzroy's or Eastern Community Legal Centre or Peninsula, which have really sophisticated, good programs. There's a lot more we can do in community legal centres to streamline the training and equip people that get better inductions. There's too much variance between the experiences that students get, and sometimes they're thrown in the deep end, improperly supervised, and other times they have a fantastic experience, and that came through very strongly in a survey that the Law Institute Young Lawyers Committee did with us around experiences and career paths in CLCs.
Katie, I'd be interested to know whether Amnesty would be interested in the idea of picking up people who are waiting in a queue to get into a CLC to volunteer their legal skills.
Absolutely. I mean, we do benefit from this comment. We had our first secondee lawyer last year working with me in my team, governance, rules, and our second one this year, and it's fantastic, and I hope they're benefiting from it as much as we are. But we certainly have refugee caseworkers, which is a large team of volunteers, either being interns, so part of their university course, or young lawyers who've just graduated and want to get a bit of hands-on experience in NGO. And they're really, really popular. We do require from people that they have a minimum of 3 days because we handle people's cases, and so a high turnover or only 1 day a week doesn't really work for that kind of work. But absolutely, we welcome anybody who has a legal interest, particularly in human rights or even domestic law, to come and either work in the sexy part of governance or in the refugee casework team.
I think volunteering is best for both parties when it's structured and there is mutual expectations of what you're going to get out of the experience. And I would encourage you, because I think it's actually incumbent upon our institutions, so universities, to be doing more and better clinical legal education programs. So where, as Hugh said, students are getting credit for the sort of volunteer work doing. There's a couple that run in Victoria and they run well. But every law school should really have clinical legal education programs which are supporting CLCs or supporting legal aid commissions. So I would encourage you to all go back to the universities that you're coming from and speak to the law school, speak to the dean about what sort of clinical legal education opportunities are available and are very much should be part of a good law school curriculum.
You've each of you had sort of hardcore, big end of town careers, and you've also gone into the social justice arena. What have been the most satisfying parts of your career?
The most satisfying part for me was when I was running the campaign on human rights and security. We were talking about people who were extremely unpopular at that particular point in time, so, early noughties. But what we were talking about was straight out rule of law and fair trial standards and prohibitions against torture. The real stuff. It didn't matter how popular or unpopular the particular issue was. We were really up there standing up for things like fair trials, anti-torture, rule of law, and I found that unbelievably satisfying.
For me, so I've been a decade in community legal centres now and 5 years in Malson, so it really was that first 6 months of the Brisbane Community Legal Centre that was probably the most rewarding time in my career. I still remember the faces, the stories that the clients told me. I eventually got offered a job at Baker & McKenzie in Hanoi and a job managing the Brisbane Community Legal Centre, and I sort of had these career pathways ahead of me, and I chose the Brisbane Community Legal Centre for a range of reasons, but it was the best career move I ever made. But what I loved about that work was the interactions with the people, the clients that I was helping, We had, I got my international experience in the city of Brisbane because I was on the phone to interpreters with Vietnamese, African clients every day. I moved on from that because my passion is law reform and policy and social change, and you can have more impact if you do that at a macro level rather than the micro level. But the most rewarding thing for me was those client interactions.
The most rewarding experience was a couple of years ago. I worked with a man called Maloon Kotari, who was then the United Nations Special Rapporteur on the right to adequate housing. And we had, through the Homeless Persons Clinic, where I was working at the time, we had helped organise an official visit to Australia by Maloon, and he spent sort of 11 days touring the country and looking at how we were complying with our international right to adequate housing here in Australia. And then I went to Geneva and presented an NGO report on housing and housing rights and how they were being realised or not here in Australia. So kind of following that work from a very local basis, so meeting clients who are homeless down at Credo Cafe or at the Big Issue, then working on much more, or taking those issues really into a national and then to an international level was really exciting. And
there are two sets of legal practitioners that have really stood out in my experience, and for different reasons. The one is the legal practitioner who works at a very grassroots level, largely in the equivalent of a CLC or a paralegal centre, that really have provided in many areas of the world, and this is beyond Australia, very many areas of the world that are really the backbone, if you like, of an access to justice fabric for people who are really facing severe deprivation of right. So working around, for instance, the loss of land rights or issues of in conflict situations. Also I've worked extensively in HIV, AIDS environments and so on, where really issues of rights are really about life and survival. And those practitioners really have provided in many instances the only route through to justice and so on. So the other level, I would say, is on the advocacy level. Those practitioners that have had long experience perhaps in the big law firms and so on, that have begun to focus their efforts on social reform and rights reform, have been some of the most memorable people that I've worked with. They've been able to bring not just a life commitment, if you like, or a values commitment to their work, but immense legal professionalism and experience and insight. And some of those people are the ones that actually, have led some of our campaigns that have changed national legislation or constitutions even of countries. Just that insight, that ability to bring that to bear. So I think that on either respect, if you start your career very early on in a, if you like, a community rights setting, I feel that that could be a very fruitful career. But on the other hand, building up your experience, building up your expertise, and then following your values through to that to try and focus that on an area, if you like, of advocacy or an area of community rights is enormously influential and I think very fulfilling at the end of that.
I think tonight everything we've heard has underlined the fact that there are ways of practising law and achieving justice. Nice to keep the two together if you can. Please thank our panel members.